and I reserve all my rights before I cross this bar.
Sure. Let the record reflect that you are a living man, because dead men cannot speak. So, and I can hear you
It's fraudulent presumed anyways, though.
All right. So, this is people of the state of Michigan versus Eric and Martin. Today's date and time set for a pretrial in this matter. Are there any issues that need to be brought or raised before the court?
Excuse me, if I may at first. Mr. Martin indicated he did not want me as his attorney, so I'm asking for permission to withdraw.
All right, I had, first off, Mr. Martin, I had previously appointed Mr. Gazicki as your house counsel. Mr. Gazicki has made a statement that you do not want, you have indicated to him that you do not wish for him to be your attorney. Is that correct?
Yes, and not just him, any attorney, because I will not be allowing attorney to turn me over to the court, the jurisdictional court, which is what they do. This is why I don't set them normally.
All right. So you want to represent yourself, is what you're saying?
Not represent myself, but present myself.
Present yourself, represent yourself, same thing, sir. Again, we're not going to play semantics like you did the other day.
Yep.
So
the law is based on
it's the same thing, sir. It's the same thing, literally the same thing. Look at the thesaurus, present, represent, sure. All right, so the motion is granted. You can withdraw, sir, Mr. Gazicki, and Mr. Martin, you'll be presenting and or representing yourself in this matter, because you have a constitutional right to do so, and you can. So, today's date and time set for a pretrial. So, Ms. Sobe, you have not had the opportunity nor chance to speak with Mr. Martin, who is improper. Is that correct?
That's correct, Judge.
All right, so I'll allow the two of you. I will set this case over and I'll let
Judge,
you
if I
two
may,
discuss the matter in the hallway or in your office, and then I'll recall the case after you guys have had a chance to pretrial the matter.
before we get into that, Judge,
Sure.
I do want to put on the record that my victim's advocate, Ms. Delisha, has been in contact with the complaining victim in this case at great length, and there is a no contact order. The victim is the brother of the defendant in this case, and he's notified us that he is still living in the same house. So the defendant and the victim are living in the same house, even though there is a no contact order. Further, the complaining witness has indicated to us that he's being threatened by the defendant in his own home, once again violating that no contact order.
Are you really surprised? This is someone who's already been charged twice and clearly doesn't believe the law applies to him in the first place. On top of that, he ignored a court order meant to protect someone else and kept causing problems anyway. When you look at the pattern, this kind of behavior sadly feels predictable. So no, I'm not shocked at all.
The complaining victim, to my knowledge, is in the hospital at this time. He's unable to zoom in, even though he wanted to be here.
He's in the check-in room right now.
He's been attempting to, but he is in the hospital, could not be here in person. He might have audio issues.
I think they're in the, I don't know what this thing is. I got Kurt Martin
Yes.
in the check-in room. So if you want to zoom back in, or you jump in back in on Zoom, Kurt Martin is in the check-in room right now.
Yes, the people just wanted to bring that to the court's attention, the multiple violations of the no contact order, the living in the house and the threatening and speaking to the complaining witness.
All right, so sir, are you still living in the same house with the victim?
I object to that question as violating my right against self-incrimination, so I will not be answering that question based on that. And also I want to object to her what she just mentioned. First, I want to mention allegations that I'm there. That's not sufficient evidence that I actually am there. And number two,
I'll just have a bond hearing, is what I'm saying.
Well,
and then everybody will be sworn in and all that kind of stuff. Because I've already given you bond conditions. Part of those bond conditions was that there should be no contact with the victim. If you're living in the same house with the victim, you need to go somewhere else.
well, first of all, he ain't a true victim. So something I'm object to. First of all,
First off, listen, you're not gonna. I'm not even gonna entertain any of your stuff. This internet, Google the internet type stuff that isn't even real or true. All right, I've already ruled on most of your motions, and I'm gonna let you rule. I'm gonna let you bring your motions again. And I'm gonna make rulings on them. But what I'm saying is, you don't have a choice in the matter. I gave you bond conditions. They're alleging that you violated the bond conditions. So under the Constitution, I can't just say, oh, you're in violation. No, I need to have a bond violation hearing. And if you are in violation of my bond conditions, then I can hold you in contempt. If you're not, then you're not, and the case just goes forward. It's as simple as that. It's called due process. So what I'm saying is, when she says you object, when you say you object to the alleged violations that she's alleging, listen, you don't even get a chance to object to that. That's their job that's their job to bring those. And if they're correct, they're correct. If they're not correct, you have the right to have a bond hearing. And at that bond hearing, if it gets proven by preponderance of the evidence that it is true that you violated my bond conditions, then I will proceed accordingly. And if not, then the case will just go forward and you'll still have all your constitutional rights. So what I'm saying is your objection is overruled because there is no objection that can be made to allegations, because that's all they are, is allegations.
So objection made based on the Constitution. There's no sufficient evidence that he lied.
You really don't understand what's happening here. This isn't the moment for objections. This is the moment where you're being informed of what's coming next. You're going to have a bond violation hearing soon because you failed to follow the conditions you agreed to. That hearing is where you can bring up all these questionable legal arguments, and the judge will decide what to do with them. Right now, this isn't a debate. It's a warning.
This whole case
Sure,
is
you're
based on him
testifying. You're
lying.
not going to testify. You're not going to testify. When you get your, listen, you're not going to testify. If you want to testify at your bond violation hearing, you can do so, or you have the right to remain silent, and anything you say can and will be used against you. So what I'm saying is, the only reason I'm cutting you off because I don't want you to step on your own constitutional toes. Everything you're saying could be used against you. So I don't want you to say something that you didn't mean to say, and then all of a sudden, then they get to use that against you, because that's your right to remain silent. You understand that, right? You understand what I'm saying? Okay, I'll take your silence. I'll take your silence as an affirmative.
No.
So, well, you didn't say that you didn't understand. So
No, I do not understand.
you don't understand.
I stand under with anything you're saying. So, but anyways, this is discussion for emotions.
From an English standpoint, that you're not standing under anything. I didn't build a bridge. I didn't build
legally, it's not all
I
based
didn't
on.
put up an umbrella. I didn't put up a canopy. I didn't put up any kind of other item that you could stand under, a ladder, you name it. So there's nothing that I've said that you can stand under. But what I am saying is you do have the right to remain silent. Anything you say can and will be used against you at trial. So that being said, I'll let you go into the hallway. You can meet with Ms. Sobe and have a pretrial in this matter, and then we'll deal with after Kurt talks with the victim advocate, and then you talk with the victim advocate. We'll decide when we're going to have the violation of the bond condition hearing.
Thank you, Judge.
So I'll remind you, this case is scheduled for a motions hearing, and
So the two of you can go out and have your pretrial.
My demand.
I just told you go out in the hallway and have pretrial. If you don't want to talk to her, then don't talk to her. That's up to you. But what I'm saying is right now.
Okay, I'll talk to Fire. What I'm saying, but right now, I have these.
Sure, you're not controlling these proceedings. I said right now is the time for you and Ms. Sobe to have a pretrial. If you're going to have a pretrial, we'll do that. I'll control when cases get called in front of my court. Thank you very much.
Yeah, you can tell Judge Slavin has had enough of Eric Martin and the way he handles things. So Eric Martin and the prosecutor step outside for their pretrial discussion, but it clearly doesn't lead anywhere productive. Not long after, they come back into the courtroom and immediately start going back and forth again. And just like before, the argument jumps straight to jurisdiction, with no real progress made.
Dismiss the case for lack of jurisdiction is denied. 1, you live in Taylor. 2, you allegedly committed a crime in Taylor. 3, the complaint was filed here in Taylor and was sworn to here in Taylor. So under that Constitution, you have availed yourself of the jurisdiction. You live in Taylor, you enjoy all the protections of the police department, the fire department, garbage services, you name it. You have more than adequate minimum contacts with the jurisdiction, and I find that your motion has no merit and is denied.
I object to that. As my argument, Article 3, Section 2 of the U.S. Constitution, that's totally irrelevant to when a state's a party. This court doesn't have original jurisdiction. Only the U.S. Supreme Court has original jurisdiction on Article 3, Section 2. And Article 3, Section 2 doesn't allow them, as reasons, to deny or to say that you do have jurisdiction. They do not allow it.
Sure, Article 3, Section 2.
Denial.
Again, your motion is denied. Article 3, Section 2 of the United States Constitution deals when one state sues another state. And that's like trash cases like New York versus New Jersey, things like that. But they have original jurisdiction over those cases. This is the state of Michigan versus an individual who lives here in Michigan, and that's you. And so, living man, living trust, living Stewie, whatever you want to call yourself, guy, big E, little G, I don't know, whatever, all that good stuff, big M. None of that makes any sense, nor does it make any difference legally. The fact that I have little yellow tassels around the flag over here, that doesn't change anything either. This is the United States. Sure, keep on mumbling. This is the United States. This is Taylor. You live in Taylor. You committed a crime allegedly in Taylor. So the case is going to start here in Taylor. And so that's why I have jurisdiction over you for the reasons stated on the record and just the obvious the United States Constitution and Michigan Constitution. I have jurisdiction over this case. So that motion is denied.
Like I've said before, this isn't Judge Slavin's first encounter with this kind of situation, and it definitely won't be his last. He's very familiar with the Constitution and understands exactly how these arguments usually play out. Because of that, he knows how to manage people who come in confidently pushing shaky legal ideas. He stays calm, sticks to the law, and keeps the courtroom under control.
With regard to bond conditions, your motion to stay or set aside or dismiss the bond conditions is denied. The Michigan court rules, which are set forth by the Michigan Supreme Court, are the ones who specifically state that I can set bond conditions in order to do a couple of things. One, to make sure that you appear at court. Two, to make sure that there's a difference between the parties or allegations of violence against the parties or between the parties, that I can keep the two parties separated in the meantime. So you need to be not living in the same place as the victim in this matter. Now, at the bond hearing, I'm going to set a bond hearing for the alleged violations of that bond hearing, because one of the things I need to know is who owns the house, like legally owns the house. Because I'm a big proponent of property rights, and that was one of the biggest things that we moved over here and created a constitution, and why property rights, and you can't just take people's property and all that kind of good stuff. So somebody's going to be moving out in the meantime during the trial. I don't know if it's you or if it's the victim. Whoever actually owns, like owns the house. I'm not going to order somebody to move out of their own house and let a victim or alleged victim stay in a house that they don't even own. The victim will move. That's how that's going to work. So if you want to check with the victims and see who actually owns the house.
To my knowledge, I believe it is the mother's house,
Okay.
and they are brothers.
And the mother is still alive?
To my knowledge.
Okay.
Is she alive?
You talking about my sister, Lisa Martin? No, she always takes saying she owns it. She don't own nothing.
Who owns the home?
Well,
I'll just look up the Wayne County Register of Deeds. Council, just make sure you just do a search in the Wayne County Register of Deeds, find out who owns the home.
Well, under adverse, non-adverse possession law, because I've been living there a minimum of 15 years under that state statute.
No, you see, again,
Listen,
listen. You just have no law, I literally teach it. So just telling you, you're wrong, because you can't have adverse possession with permission. If you have permissive use of the property, you'll never, ever, ever going to get adverse possession.
Adverse or non-adverse, okay?
Okay, there is no non-adverse, trust me. I don't remember that one ever being on the bar exam. You know what? Hey, whatever bar exam you want to take, you let me know. I'll study for that one too, and I'll take that one.
I'm really not convinced that Eric Martin wants to go head-to-head in a serious legal debate with Judge Slavin. When it comes to the law, Judge Slavin clearly knows his material and stays grounded in actual legal principles. Eric, on the other hand, seems to be operating on a completely different level, relying on arguments that don't really hold up. It's an uneven matchup, and it shows the moment things get technical.
But to answer your question, let me finish saying, you always want to try to cut.
No, because I want to wait till everybody's under oath. I'm just saying, I'm staying at the hearing. I want to know legally who owns the property.
I was also mention no, we can do that too. I'm just saying, but it's always.
Oh, we're not ready to do that now
house
today.
Justin, it was always my parents, right? House, so to say, and I don't even think they really owned it because the mortgage wasn't paid off. So I don't think really no one totally owns
it. A
it.
mortgage is just a promise to pay money. It has nothing to do with actual ownership. Ownership and mortgage are two different things.
I think actually all of us at the house are possessors of law. My understanding of law is we're actually possessors because the bank really owns because the mortgage was never paid off, my understanding. But it was always, so to say, our parents' house. Like I said, I don't think they really owned it.
Sure, here's what I'm going to do. I'm just going to go ahead and sua sponte, look it up in the Wayne County Register of Deeds myself because it's a matter of public knowledge. And then I'll take judicial notice of the fact who's the owner.
Like I said,
That's all I gotta do.
adverse and adverse possession, MCL statute.
What we're gonna do is we're gonna have a hearing date. And that hearing date is gonna be on the same date as the jury trial. So in the meantime,
I have a right to be there though, because I've been there minimum
didn't say
15
you,
years.
I
By
mean, you
state
don't have a
statute.
right to be there, so you don't own the
Sure.
property. You don't own the property.
Under that statute, I am.
You don't own the property. So you need to vacate the premises, because that's where the victim was. I told you no contact with the victim.
And that's an unlawful void order because it violates.
But it's not.
Because without any evidence, you can't just say, I can't be
Okay,
at a
so
house.
listen, sir, I'm gonna tell you one more time. I'm not gonna sit here and argue with you. If you keep arguing with me in court here, I'm gonna hold you in contempt because you're just holding up everybody else who's ready to go and proceed with their cases. And you just keep bringing up the same thing that isn't anything at all to bring up. I've already agreed in my ruling on your motion. I've denied your motion. I told you that you can't live in the same house with the victim on a domestic violence case when I told you you have no contact with the victim. And if you don't own the house, now if you own the house, like actually own the house, like show me the deed that shows that you are the Wayne County Registered Deeds, that you're the owner, I'll make the victim move. Why? Because I'm not gonna kick somebody out of their own house. I'll make somebody will move, but it ain't gonna be you then. But you don't own the house. Okay, so you're gonna need to vacate the premises. You're gonna need to vacate the premises.
Okay, and I objected, like I said, it's not just a deed whether someone owns it. Under the statute in Michigan, it mentions.
First off, what statute? Cite the statute.
Okay, I don't have it right in here because I was going to raise, but I'm going to give you the statute. You already know me. I cite MCLs all I know problem. So I'm going to give the MCL statute, but it deals with what's called non-adverse or adverse possession. Okay, so you live one of the basic elements. You lived at a house for 15 years, right? Remember, this is my parents' house, right? I've been there 30-something years. When you lived in a house that long, you are considered part owner, at least, if, you know, so, and therefore a right to be living at that house.
No, that's not how it works. You don't automatically gain property rights just because you've lived somewhere for 15 years. What he's actually referring to is Michigan Law MCL 600.581, which sets time limits related to real property claims. Specifically, subsection 4 talks about a 15-year limitation period, and that all other cases language applies to adverse possession situations, basically squatting cases. Eric Martin's argument is that staying there long enough should give him the right to remain, even though the situation clearly involves ongoing problems. That's not how the law is meant to be used, and it doesn't justify continued behavior that affects others.
No.
So it ain't just whether you have a deed or not. That's, and regardless of the ownership.
No.
Yes.
No.
No. Okay.
You have a
MCL
possessory,
statute,
after 30 days, if you stay in a premises with permission, after 30 days, you become a de facto month-to-month leaser. And you become a leasee at that point, and you have a lease with the property. That's it, at best. And that means you can stay there and they can evict you, or I can give you a bond order that says you need to vacate the premises. That's a court order.
Owns it, maybe, yeah, but
You don't own it. You don't get a possessory interest, but you don't get an ownership interest. There's an absolute difference.
No one owns it.
There's an absolute difference. Listen, you're not gonna argue with me. Keep arguing with me and I'm gonna hold you in contempt. Because I'm telling you, you don't own the property. You have a possessory interest at best, because you've been there for 30 days, sure. And they can either evict you, or a bond condition can move you out. Either one. Or actually an injunction from the circuit court for if there was a case, they have the power to move you out of there as well. There's 3 different scenarios where you could be moved out of there. One of them is bond condition. Bond condition says no contact with the victim. You don't own the house, get out. In the meantime, get out until the case is done. So if I find or know that you are there, I'm just telling you, I will hold you in contempt of court. I will remind you that contempt of court is a misdemeanor punishable by 90 days in jail and up to $1,000 in fines. And I'm just going to let you make sure that you are aware of that. Again, ask you, would you like any court-appointed attorney to help you in this case?
No.
Okay.
I have more to say now. And
Just double check.
Part of my constitutional rights.
Just double checking.
The order, first of all, the bond order violates my due process because you can't tell me to be out of the house, my house I've been living in all my life.
It is because it's not your house. You keep saying your house and it's not your house. It's the place that you were allowed to stay by your mom and daddy. But now they're no longer, this is not that situation anymore. It's not that situation anymore. So you don't own the house. You're all grown up now and you don't own the house.
I'm going to need to see an actual citation for this idea that Eric Martin is suddenly a fully independent adult now. But you are absolutely right when you told him directly that the only reason he's still living in that house is because his parents allow it. There's no legal argument backing it up, just permission from the people who own the place. When it comes down to it, That fact matters more than anything he's trying to claim.
And the person who, and I'm telling you, you need to vacate the premises because the victim lives there. So you're gonna vacate that premises. So your motion to set aside the bond conditions is denied, because I clearly, you can't understand simple concepts that I'm trying to tell you. So I really don't want you to have in a position where you're in the same building with the victim. Because since these allegations are ones of violent nature, I don't want that to happen allegedly to the victim again. So your motion for jurisdiction is denied. Your motion to dismiss or set aside the bond conditions is denied. Let's see what else you got. Motion, copy. You already got a copy of the complaint, so I granted that. There's your copy of the complaint, and plus check your email. Counsel did say she sent you all the paper discovery. We're going to get you a copy of the rest of the discovery as well. And then you had a motion which was basically the same motion as the other two, but just put all together into one. That says motion to dismiss because of lack of you're challenging the standing and challenging the standing of the people to bring the case.
Well, the corporation of the state of Michigan is linked to.
Oh, the corporation. Well, under the Michigan Corporations Act, I'm going to allow the standing. Everything's good. And for the reasons already stated for jurisdiction, it pertains to the standing as well. And the people actually have a duty to bring cases when they think that there's probable cause that crimes have been committed. And it is their obligation to bring those to the courts that have jurisdiction, hence this court. And they did that. Motion to stay on lawful bond conditions, that's denied for the reasons stated in the other motion that was asked to get rid of the bond conditions. And then the third part of that other motion was get a copy of the complaint, which you already got. So denied, and partially granted, and you already have a copy. So all of your motions are been answered.
No, I still have more, but before I get to the other ones, I have.
Well, we're done for today, so you're going to be getting the date and time for the jury trial. Your
I have
motions that you filed to dismiss the case and to set aside the bond conditions have been denied. I'm going to get this jury date set, and then I'll hear any other dispositive motions on that date. I'll hear the bond violation hearing on that date, and then if there's going to be a trial, then we'll go ahead and hold the trial on that date.
So refusing to hear other demands, I had to dismiss.
Sure, I have three motions that you have in front of me. I've made my ruling on 3 motions.
Yeah, but Judge, you haven't even heard his 3 new oral motions asking you to reconsider the ones you already denied earlier today. On top of that, he's got his usual sovereign citizen-style arguments in his motion. Luckily, Judge Slavin has a clear answer for all of it and isn't letting any of these tactics slow things down. It's basically the same pattern as always, and the judge handles it smoothly.
But I'm saying I have more to make right now verbally. I have more based on she has no standing as the prosecutor. That's one of them I have to make. So
Okay,
if I want to make it,
you know what? You just made the motion. I'll rule on the
no,
motion.
but I ain't finished.
Motion,
No,
first
it's not
up.
a motion. It's the demand
Just
because it's based on my constitution.
Demand motion, call tomato. It really doesn't matter. A motion is you're asking the court to do something. We're demanding the court to do something. Ms. Soap, do you work for the Wayne County Prosecutor's Office?
I do.
Does Wayne County Prosecutor's Office have jurisdiction under the Michigan Constitution and under statutes to prosecute cases that happen and any alleged crimes that happen in the county of Wayne?
I do.
And you work for, who is your boss?
Worthy.
Kim Worthy. Kim Worthy is the elected Wayne County prosecutor for the county of Wayne.
Yes, Judge.
All right, motion denied.
You didn't
She
hear
has-
my argument
she-
though. You
she
can't
has
just
standing.
go by what-
She has standing. She's doing her job.
I have not made my argument. Based on my motion.
Sure, make your argument.
It's okay. My
Make your
argument
argument.
is she has no standing because she does not have a power of attorney with the so-called corporation, state of Michigan, or city of Taylor. Since she has no power of attorney that she can show to the court in evidence, she has no standing. Because she can't possibly have a power of attorney because a corporation is a non-living human. So she can't possibly have a power of attorney with the city of Taylor or the state of Michigan, which is the plaintiff here, the real plaintiff. Therefore, she has no standing.
All right, after hearing your argument, I'm again denying your motion.
Based on what?
Based on what? Based on everything you said is all legal mumbo jumbo. It makes no sense whatsoever. Like literally, if you want to know the action, it has no basis in constitutional law. It has no basis in statutory law. The fact that you're saying that a prosecutor can't do her job, she's literally hired by Kim Worthy, who is the elected Wayne County prosecutor, who under the Constitution and Michigan statutes, criminal statutes, Revised Judicature Act, and the Michigan Constitution, all coming together to give this court jurisdiction to make rulings on any crimes that happen in this jurisdiction, which they have alleged that you have done, and you've got a copy of that complaint. And now they are sending their employee, okay? Because you want to talk about agency, you want to talk about power of attorney, I don't need to. When I hire somebody as my employee, I send my employee and they have what's called a parent and actual authority. Could be both, could be either, doesn't matter. That means that they send that person who has such a parent authority to go and act on, wait a minute, on their behalf. And Kim Worthy isn't here right now. That's why she is an assistant prosecuting attorney. And she is here at the whim of and under the control of Kim Worthy, who is the prosecutor. Now that's a legal argument that's actually based in law, okay? Yours was not based in any law that this court would ever recognize.
You can represent humans, maybe, not corporations.
I didn't know. I know you're a living man, you said. I didn't know if you were a living man, and I didn't know if man was human. I didn't know which. I didn't want to be presumptuous. I didn't say human or anything like that. But I just know that you were a living man, you said. But the court does recognize that because, again, dead people can't sit in my chairs and talk. So your motion is denied. All right. And you're gonna get the court date for the jury trial in the mail, and that'll be for all the rest of the matters as well.
Alright everyone, that's it for this video, but it's not the end of the Eric Martin saga. We still have at least one more jury trial to go, and who knows what will happen next. If you want to follow the full story as it unfolds, I'll link 2 channels in the description that have been covering the saga in a much more organized and uninterrupted way, Old Squishy, Garda, and Colin. If you enjoyed the video, hit the like button. If not, hit dislike, but don't forget to leave a comment and subscribe with notifications turned on so you won't miss any of my future content. Thanks for watching.